This is a week of many firsts in the law and politics intersection. We have our first preliminary injunction issued on behalf of a class by Judge Rodriguez in the Southern District of Texas, who declared that the Trump administration use of the Alien Enemies Act to summarily dismiss Venezuelans to the deep, dark recesses of gulags in El Salvador is unconstitutional. Judge Rodriguez, a Trump appointee of all things in the Brownsville, Texas division, made the ruling on a 36-page decision. I'm going to give you why he's right and why this should rock the world of Donald Trump, coming off of 2 losses at the United States Supreme Court against Donald Trump in the area of immigration. And one thing he thinks was a win, but really was not. I'll break it all down for you here on Legal AF. All right, so what happened? After about 3 weeks ago, when the United States Supreme Court gave Trump sort of a temporary procedural win in a case we call JGG, coming out of a matter from the District of Columbia in front of Judge Boasberg, in which the court said, Judge Boasberg, you were right and you were wrong on procedure. You were right in principle, you're wrong on procedure, and here's what needs to happen going forward. Donald Trump heard, I won? Well, not exactly. What the court in JGG said, by a 6-3 vote of the United States Supreme Court, which matters here in this analysis I'm doing for you, is that the court said the issue of whether the Alien Enemies Act was properly invoked or not is not for Judge Boasberg in a class action in Washington. No, it's for individual, or what we call the route of habeas corpus, that the court wanted the procedural mechanism for the parties to use with not a class action alleging constitutional violations or violations under the Administrative Procedures Act. No, they wanted this ancient use of a vehicle called a writ of habeas corpus, where a prisoner or somebody that has been detained files an application to get before a federal judge and bring the body into court. The writ of habeas corpus. We will have the body. And so that means that instantly the American Civil Liberties Union, who's representing many, many of these groups of Venezuelans, rushed into action and within days had filed petitions everywhere these individual Venezuelans still existed in the United States, because that's what the Supreme Court said in the JGG decision. They said the federal court shall be the court where the party is at present before they got on the plane, and that judge has power under the writ of habeas corpus to determine those issues. ACLU files in Colorado, in New York, in Texas, Northern District, Southern District. This is the case in the Southern District before Judge Rodriguez. Okay. Now, 2 things are rubbing against each other here in this particular matter. MAGA and Trump do not want any class actions. They want each of these to be individual petitions for individual 500, 600, 2,000 member, Venezuelans. They want 2,000 cases, divide and conquer. Whereas the ACLU, of course, for judicial efficiency and other reasons, wants to group them together in classes. And so that's one major issue we're going to watch through the Supreme Court. In the Rodriguez case, in the Fernando Rodriguez case down in the Southern District of Texas, it is a class action that's been certified for all Venezuelans subject to this proclamation under the Alien Enemies Act under Judge Rodriguez's jurisdiction. They're the class. And what has the judge just ruled? He's just ruled first judge, even though I told you there's 6 or 7 cases around the country so far, but he is the first one to enter a preliminary injunction, yes, to stop the use of the Alien Enemies Act to deport and remove these people, which means Donald Trump's going to have to use other mechanisms through the immigration process to bring these people to an immigration judge, give them due process, duke it out in court in the adversarial process, prove their case, and if they're criminals and members of Tren de Aragua, the criminal gang, from Venezuela, fine. Then they'll be deported and removed. But if they're not, they're not. And that's going to go through an immigration process, not a federal court per se process. That's one. The second major thing he ruled is that there was no proper exercise of the Alien Enemies Act, that it was unconstitutional by Donald Trump, period. That there has to be a predatory incursion, which is equivalent to a war or invasion during a war, although not exactly, but it has to be something similar to that. And that the migration patterns of a bunch of narco gang members coming into the United States over a number of years, including during the first Trump administration, doesn't count as an enemy incursion or predatory incursion. And if you don't have that present, that very trigger, you can't use the Alien Enemies Act, so says Judge Rodriguez. Let me read to you from parts of his opinion that matter. Rodriguez wrote that the Trump administration, quote, does not possess the lawful authority under the Alien Enemies Act, the AEA, and based on that proclamation in which Donald Trump effectively declared war against Venezuela, to detain Venezuelan aliens, transfer them within the United States, or remove them from the country. You got to use another method. We already have it on the books in the way we treat the immigration process. You just can't use the Alien Enemies Act to round up everybody and send them off to a gulag. The president, as the judge wrote, cannot summarily declare that a foreign nation or government has threatened or perpetrated an invasion or a predatory incursion of the United States, followed by the identification of the alien enemy subject to detention or removal. Allowing the president to unilaterally define the conditions when he may invoke the AEA and then summarily declare that those conditions exist would remove all limitations on the executive branch's authority under the AEA and strip the courts of their traditional role of review. Now, what the judge did very smartly was compare a couple of lines of cases with the United States Supreme Court, knowing this case ultimately will get to the Supreme Court. There was a case called the Mott, M-O-T-T decision, in which the Supreme Court said the way the Militia Act, a whole different body of law, was written, there is no judicial review. But that's in contrast to a case called Ludecky, another Supreme Court case, in which the court looked at the Alien Enemies Act and said there was judicial review. See, Donald Trump's arguing, Commander-in-Chief, judges have no role. I declared them enemies. I declared them that they're at war with us. I get to deport them. No, not under the Alien Enemies Act. Because Congress, when Congress wants to make sure that something's not reviewable by a federal court, and I'm talking about old-timey Congress, 1798 Congress, they know how to write that into the statute. And so the judge smartly contrasted, here's an example where Congress said no judges' involvement, and here's one, Alien Enemies Act, where they said there is judges' involvement. And that's why the Supreme Court ruling in Ludecky and then cases after that, like JGG, are so important. In fact, the judge reminded everybody in his opinion and in his analysis that even 3 weeks ago, in that JGG case I just talked about, coming out of Judge Boasberg's chambers up to the Supreme Court, 6-3, they said that federal judges have the right to do review of attempted removal under the Alien Enemies Act, including whether it's constitutional or not. See, Donald Trump and his minions jumped up and down when they got the 6-3 decision. Yay, we can use the Alien Enemies Act. At your own risk, until a future judge at the trial court level declares whether it is or is not constitutional. Hence, we have our first unconstitutional declaration by a federal judge. In fact, if you read on page 31, and I'm going to post this entire order on Substack for Legal AF. Come on over to Substack Legal AF, and you'll find this particular order posted there. So the judge says, on page 32, having determined the meaning of the relevant statutory terms, the court considers whether, as a matter of law, the proclamation by Trump declaring Tren de Aragua enemy combatants exceeded the statutory boundaries that the Alien Enemies Act establishes. And the court concludes that it did. It then went through how these Venezuelans got here, the TDA activity in America, the Tren de Aragua activity, and the argument about whether we are at war or something similar to it with Venezuela. He then concludes on page 34 that the president's invocation of the Alien Enemies Act through the proclamation exceeds the scope of the statute and as a result is unlawful. Respondents do not possess the lawful authority under the AEA and based on the proclamation to detain Venezuelans, transfer them within the United States, or remove them from the country. In its conclusion, the court says on page 36, the court has concluded that all of these individuals, including JGG, in their individual capacity and as representatives of the certified class, have demonstrated entitlement to relief in habeas, satisfies the Supreme Court's decision from 3 weeks ago. The respondents have designated or will designate them as alien enemies. The certified class warrants similar protection. The court will issue a final judgment with appropriate relief. To the extent that anyone has been detained pursuant to the Immigration and Nationality Act, they have not sought relief. So in other words, the judge is saying, you want to get rid of these people? Go through the Immigration and Nationality Act. Go through an immigration administrative law judge and prove your case. But get out of here when you're talking about the Alien Enemies Act. What's going to happen next? Fifth Circuit Court of Appeals leans all the way to the right. Right? Everybody there is trying out to be on the United States Supreme Court should there be an opening with Trump. So the Fifth Circuit is going to get this case in New Orleans, I'm sure in the next day or two. They're either going to issue a stay. There's going to be an application to stay and block Judge Rodriguez's order, which they'll probably grant. And then they're going to kind of get around to ruling on it. And then somebody like the ACLU is going to jump the gun and they're going to file an emergency application at the United States Supreme Court. Somebody's filing an emergency application. Probably the ACLU, could be the Trump administration, would be their 13th. And then they try to come up with Judge Alito is the head of Texas for the Supreme Court. He'll probably send it right over to the other 8. And then we're going to have yet another over the summer emergency application with this United States Supreme Court about whether the alien, and now it's at the heart of the matter, whether the Alien Enemies Act was properly invoked or not, as ruled by this Judge Rodriguez. He says no, and whether a class action is proper in a habeas corpus petition. The Trump administration is going to fight that too. We'll follow it all right here. A couple of ways to support Legal AF if you like this kind of content and what I'm doing here with you. Hit the subscribe button here because we're going to roll. We're going to be at 700,000 by next week. And that's subscribers. And that's all because of you. Coming over to the new Legal AF Substack. The Legal AF Substack has this 36-page order, my commentary. I do a morning sort of outline of what I've seen so far for the week and what's coming up, called Morning AF. All the other contributors for Legal AF are there as well. Substack from Legal AF. And of course, we've got the Legal AF podcast. So until my next report, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.